Thank you, Professor Badni. I would also like to extend this line of thank yous to the organizers and Professor Szilágyi in particular, under whose wise leadership we all prospered. So thank you very much. As you...
I will tell him.
He knows. As you already said, my topic today is public participation and access to justice in administrative matters in Croatia. Public participation is extremely important with regard to environmental protection. Although environmental protection should primarily be the duty of the state, our constitution prescribes that everyone has the right to a healthy life and that the state is obliged to ensure the conditions for a healthy environment. Therefore, it is the duty of the state to ensure that the environment is protected. The state does that through various means. For example, it is obliged to criminally prosecute those who commit crimes against the environment. It is obviously obliged to perform its duties according to the Constitution, international documents in force, and relevant legislature, most important of being the Environmental Protection Act. However, sometimes the state is neglected in its duties, mostly through ignorance of various acts, EU legislation, and the still existing reluctance to apply the Constitution directly, the European Convention for Human Rights, or the Aarhus Convention, which Croatia is a party of. Now it is the time to mention Article 69, paragraph 3 of the Constitution, which reads as follows. Everyone shall, within the scope of his or her powers and activities, accord particular attention to the protection of human health, nature, and the human environment. This means that all citizens of the Republic of Croatia and all residents of the Republic of Croatia, not regard whether they are physical or legal persons, functioning in the Republic of Croatia have a constitutional duty to protect the environment. Now, the following question must be answered: how should anyone protect the environment? Beside the obvious answer, by recycling, sparsely using natural resources, conserving energy, and so on, there are other ways in which an individual and or association of people, as legal persons or not, can protect the environment. Firstly, there is the opportunity to participate in administrative procedures in which building and or environmental permits are issued. Secondly, there is the opportunity to participate in making of spatial plans, which determine the usage of the land. Thirdly, there is the opportunity to participate in public debates on various legislative acts which are mandatory by law. As will be explained, everyone who can prove that an administrative procedure concerns his or her rights, obligations, or legal interests can participate in such procedures as a party. This is so as it is prescribed in our General Administrative Procedure Act, or GAPA. According to it, everyone whose rights or legal interest, protection of the environment is a legal interest, as it is a constitutional duty, and harmful effects on the environment endanger everyone's right to a healthy life. And the Constitution prescribes that we all have the right to a healthy life. If those rights are endangered by a proposed project, everyone is entitled to participate in the administrative procedures with regard to said project. So this is a legal obligation, a legal opportunity. But there are sectoral laws that made an unconstitutional path for investors by narrowing down extremely the possibility to be a party in administrative procedures regarded by such laws. It is very important to determine what and who is the party in administrative procedures. Every administrative procedure revolves around a given party, whose rights, obligations, or legal interests are decided in it. Sometimes, the question of determining the subjects who are entitled to the status of a party in administrative procedure is a complicated question for the legislator and for the implementer of a legal norm. Only a person who is given a status of a party is able to participate in an administrative procedure. This person and only this person has procedural rights prescribed by law and is able to challenge a decision brought from the procedure in second instance administrative procedure and in front of the court. In Croatian legislative conception, three types of parties can be derived. Active party, on whose request a procedure was instigated, for example, of issuing different permits. Passive party, against whom the procedure was instigated, for example, determining due taxes. And interventionist party, who has the right to participate in a procedure in order to be able to protect his rights legal interest, for example, the neighbor in a procedure of issuing building permits or location permits on neighboring plots. Therefore, the legislative definition of a party in our GAPA stands for a very broad formal definition of a party, what should enable all those whose rights, obligations, or legal interests are being decided on in an administrative procedure to participate in said procedures with all procedural rights prescribed by the law. Problems usually do not arise regarding the active or passive party, but are often when interventionist party emerge because of the need to ascertain whether their rights or legal interests are being really decided on in the procedure. It is important to note that GAPA is a general procedural act and that its application is mandatory in all administrative matters. From these two separate principles, two separate principles emerge. First, it is clear that deviations from the GAPA are permitted only in special cases and that even then the principles and fundamental provisions of GAPA apply. Second, law can regulate only particular questions otherwise. It is important that the norms of the General Act and the norms of special acts form a unified whole, allowing for a just and efficient functioning of the legal system. The position of a party in administrative procedure or the inability to obtain such a status is strongly linked with constitutional rights. Namely, in every administrative procedure, someone's rights, obligations, or legal interests are decided. According to our constitutional setup, every individual act of a public body is subject to judicial scrutiny, as all individual acts of public bodies must be grounded in law. This constitutional provision must be linked with another, which guarantees the right to a fair trial, or access to court. It is important to note that Croatia is also part of the European Convention on Human Rights and Fundamental Freedoms. This international document is a part of Croatia's internal legal system and is considered of quasi-constitutional rank by Croatia's Constitutional Court and is applicable to administrative procedures because the right to a fair trial is protected in all procedures in which rights and obligations of a civil nature is decided. When we take into account the constitutional setup which firstly binds the administration to the law, secondly, guarantees judicial scrutiny of all administrative or individual acts of public bodies, and thirdly, the right to a fair trial or access to court, and the European Convention, which also guarantees right to a fair trial, which applies to administrative procedures as well, one only has to acknowledge that the right to participate in administrative procedures as a party is and should be a protected fundamental right. Furthermore, denying the status of a party to a person who should have obtained such status leads inevitably to the denying the same person the constitutional and conventional right to access to court and fair trial. If an outcome of an administrative procedure can be detrimental for the rights or legal interests of a person, such person must be able to protect the said rights or legal interests while the administrative procedure is ongoing. This can only be done if such a person is granted the status of a party in such a procedure. This is usually so, and GAPA applies in all cases. However, there are certain sectoral laws which very narrowly define the status of a party. So, for example, our Construction Act, which regulates the issuing of building permits, provides party status in administrative procedures very narrowly, only to the investor, owner of the plot, and owners of surrounding real estate. There are even greater restrictions if the building permit is issued for building a building which is of interest of the Republic of Croatia, or for such buildings for which the permits are issued directly by the ministry. When the status of a party is given only to the investor and owner of the plot who is on which the building will be built. One must mention that the practice of administrative courts has been rather strict concerning the determination whether a person fits the criteria surrounding real estate when they can be parties for neighbors that are entitled to the status of a party. Even more striking example of narrowing the possibility to be granted the status of a party can be found in the same act, which prescribes that the party in the procedure of issuing a usage permit for a building, so this is a permit which tells you that the building is technically safe and sound, and in those procedures, only persons eligible for the status of the party are the investors. So this leads a very wide opening for corruption. Another example is the Spatial Planning Act, which narrows the possibility for a person to acquire the status of a party in administrative procedures regarding issuing of spatial permits, in which this act applies on very similar manner as I already described regarding the Construction Act. Also, the Mining Act prescribes that in all procedures in which it applies, only the owners of the real estate regarding which the procedures are being held can attain the status of a party. All others are excluded. So this restriction of a very fundamental right is by our legislators, he tries to explain it by economic gains from investment. But there are, of course, other ways to ensure speedy and efficient conduct of these procedures. Namely, one should ask himself, is economical carrying out of the procedure for a legitimate goal because of which the legislature is allowed to restrict the position of a party in administrative procedure? Of course, the principle of economical and efficient procedure exists in the GAPA, and one should abide by it. However, it is a so-called second-rate principle when it is in clash with more important principles, for example, the principle of legality or the principle of material truth. And if you deny a status of a party to a person who is entitled to it according to GAPA, that results, of course, by the violation of this person's constitutional and conventional rights, such as the rights to a fair trial, access to courts, and equality before the law. We had a very similar provision in Slovenia regarding its Construction Act, which Slovenia's Constitutional Court quashed in 2011. Our Constitutional Court does not want to decide on the matter. It has many requests regarding the constitutionality of these acts, which I mentioned, but it denied. We did not receive any decisions by the Constitutional Court for a very long time regarding the constitutionality of these acts. So, if we say there is no denying that a person has a legal interest to participate in a particular administrative procedure, and he should be a party according to GAPA, but the legislator nevertheless denies such a person this right by a special act, it is obvious that this constitutes a violation of the person's constitutional right of access to the courts and equality before the law. With this, we must link the fact that Croatia is a party of the Aarhus Convention, which is in force in Croatia since June 2007. One cannot overstate the importance of this convention for many special administrative procedures. For example, for the procedures regarding access to information on the environment owned by public bodies and procedures of deciding regarding certain activities which can have a significant impact on the environment. The convention defines the public and the public concerned. Especially the definition of the public concerned is very important, as it is defined as those affected or likely to be affected by or having an interest in the environmental decision making. For the purpose of this definition, non-governmental organizations are also included, and they are deemed to have an interest. So they must be parties in all administrative procedures which are carried out regarding the environmental issues. But this is very important, and I must stress it out. Our courts and especially our administrative bodies do not like to directly apply Aarhus Convention, which they should do, and give the status of a party to such persons, but they apply sectoral laws and deny the status of the party. This definition in Aarhus Convention is very broad, and it encompasses the persons whose rights could be violated, for example, the right to property, or, very importantly, the right to a healthy environment. However, this definition also applies to persons who are only interested on decisions on environment and who are not obliged to prove their legal interest, but only their factual interest, that they are really interested in the matter. The public concerned must have access to participation in administrative procedure, as this is guaranteed by the Aarhus Convention, but we have problems in practice with regard to the application of direct application of the Aarhus Convention. Another instrument of public participation I already mentioned is in spatial planning, as it is extremely important for every country. By spatial plans, the means of use of space is regulated, as we all know. One must also take into account that space is a limited resource, and it should be carefully used, having its limitations and the future in mind. The public must have an insight into the complete process of making spatial plans or changing them on all levels, so that the public could, on time, correct the mistakes or illegalities with special regard to environmental protection and quality space management. Additionally, a special accent must be put on the obligation of enabling the public to be able to participate in the procedure of issuing individual acts, location permits, not only in their issuing but also in their challenging in front of the court. The public has also the right to access the information on space which is owned by all public bodies. Public participation in making of and changing of spatial planning documents is an important element of their making and or change. By such participation, it is ensured that the broader public on which the spatial plan reflects on is informed on its making or change. In this manner are also the eventual conflict lessened, as various economic interests undoubtedly exist when making or changing spatial plans. This is why the carrier of the making or change of a spatial plan is required to inform the public on the municipal website and through the information system of the Croatian Institute for Spatial Development. There is a mandatory public debate on the proposal of a spatial plan, which is open to everyone. The public debate must be publicly announced no later than 8 days before it is scheduled. Simultaneously, the proposal of the spatial plan is on public view. During the duration of the public view, the carrier of the plan is obliged to organize one or more or several public debates in order to explain the solutions in the plan or the reasons for quashing of a plan. Before the carrier can send the final proposal of the spatial plan to the representative body to enact it, he is required to deliver to the participants of the public debate a written notice containing an explanation why their proposals and objections were or were not fully accepted. Then the representative body can enact the spatial plan or its changes. It is important to mention that the legality of a spatial plan can also be brought in front of the High Administrative Court of the Republic of Croatia. However, one must state that the carrier is by no means obligated to take into account any suggestions made by the public. He is only obligated to explain why he did not take them into account. Therefore, the influence of the public, although the procedure is regulated very well, is weak at best. And for my concluding remarks. Public participation in environmental matters is of great importance. It would be wrong to assume that the state is to be the protector of public interest in most matters and only the state, especially in environmental ones. The Constitution dictates that everyone is within the scope of his or her powers and activities to accord particular attention to the protection of the environment. Therefore, it is duty of all, not just the state. It is possible through GAPA, which does not allow for narrowing down the possibility to be granted the status of a party. However, there are several sectoral laws that have provisions to that effect. This means that in administrative procedures carried out according to those laws, persons who do have the right to be granted the status of a party in such procedures do not attain such right. As they are not granted the status of a party, such persons are unable to protect their rights or legal interests in the administrative procedure. But moreover, because of that, they are unable to lodge legal remedies, especially the opportunities to seek court protection in administrative dispute. It is clear that provisions in sectoral laws that narrow down the opportunity to be granted the status of a party in administrative procedure are contrary to GAPA and are not aligned with the Constitution. They are also obviously not aligned with the Aarhus Convention, which defines the public concern far more broadly than the cited sectoral laws. Therefore, such provisions should be annulled by the Constitutional Court. Public participation is very broadly regulated with regard to making or changing the spatial plans. The public is entitled to know when, how, and in what manner will this be done, and this duty of the carrier of the plan is strictly prescribed. the public has the right to object in writing or during the public debate. However, as I already mentioned, the impact of public debate or public participation is rather limited, as the carrier is not obliged to take into account the objections made by the debate or in written way. Only thing which can make the carrier to change his mind is his responsibility, political or personal, but that is for the carrier to decide whether he will risk future elections or not. Therefore, the final conclusion is that the right to public participation in environmental matters in Croatia is in general sufficiently prescribed. However, there are sectoral laws that undermine this right, which creates problems in practice and are clearly unconstitutional. In the area of spatial planning, there is a broad possibility for public participation, but with very limited real effects. Thank you very much for your attention.
Okay, Professor Staničić deals with my favorite environmental principle, that is public participation. And as Professor Szilágyi mentioned, public participation has got an increasing role in environmental policies. And the reason is that public participation has got several advantages, not only raising environmental awareness, but also reducing the enforcement deficit of environmental laws. And I think this is the biggest challenge for environmental policies and decision makers, because weak enforcement is a general phenomenon in all countries. And I am very happy to deal with the paper of Professor Staničić. As we could hear, he deals with public participation and access to justice in Croatian law. And there were several presentations on the constitutional provisions, like the right to environment. The right to environment has got two aspects: the substantial aspect and the relationship between the right to environment, the right to water and sanitation, right to food and others is very interesting. But it also has got a second dimension, the procedural aspect. And I totally agree with Professor Staničić that the importance of the Aarhus Convention cannot be overstated or overemphasized. The Aarhus Convention ensures the environmental rights. It has got the well-known pillars, 3 pillars, and Professor Staničić deals with 2 of them: public participation and access to justice. Instead of the constitutional rights and the European Convention on Human Rights, rather I would focus on the European Union and the Court of Justice of the EU, since the European Union, together with the member countries, concluded and ratified the Aarhus Convention. So there is a dual legal obligation. The member countries are parties to the International Convention, so they have to comply with the Aarhus requirements. And at the same time, they are also members of the European Union. So they have to comply with EU law as well. And that's why public participation and access to justice must be ensured in EU member countries. In his paper, Professor Staničić focuses on and lists different examples narrowing the possibilities of public participation He mentioned the Construction Act, the Mining Act, the Waste Management Act, and the Spatial Planning Act. And I also agree with him. His final conclusion was that in the area of spatial planning, there is broad possibility for public participation, but with very limited real effects. And I think the main reason is that participation in spatial planning requires a higher level of expertise and technical and scientific knowledge is necessary. And citizens and local NGOs, they don't have such a high level of expertise. And that's why the Aarhus Convention also provides legal standing for environmental NGOs instead of individuals. And under Article 9, paragraphs 3 and 4 of the Convention, the notion of review procedure is understood in an administrative or judicial procedures which shall be fair, equitable, timely, and not prohibitively expensive. And I think that's the main point, because when we talk about administrative procedures that are unfair, inequitable, time-consuming, and costly, this scheme, these mechanisms can deter the members of the public to take part in decision-making procedures. So I agree with the broad formal definition of environmental administrative procedures. Every restrictive interpretation limits the possibilities of the members of the public to participate in decision-making procedures. And I can tell you several other fields and activities that have a huge impact on the environment next to spatial planning. What is important is the definition of environmental law and the concept of administrative procedure. Well, in Hungarian law, in the Environmental Protection Act, environmental NGOs have legal standing in environmental cases, in procedures initiated against administrative decisions that operate in the impact area of an activity or facility. But I agree with Professor Staničić that in all cases where the clients, or as he said, the parties, can prove that they are directly interested, they must have access rights. They must have access to the proceedings. They must have access to justice. And well, I am a bit envy when I read that there is a central environmental administration in Croatia. And I checked the homepage of the Croatian government, and I can see you have got a separate Minister of Economy and Sustainable Development, and another person who is responsible for spatial planning, construction, and street property. Unfortunately, in Hungary, there is no Ministry for Environment that is, or with environmental responsibilities, that is in charge of overall strategic planning and setting of environmental targets. There are no independent environmental inspectorates, and it is a huge problem. Well, I am the head of an environmental NGO, a local NGO, and this year, for example, I had to bring an action against the government office. In Hungary, there is no second instance level in administrative law, so I had to go immediately to the National Court because they tried to exclude my NGO in an environmental administrative procedure. And well, I was sure 100% that I would win the case, and I won it this month because under Article 2, Paragraph 5 of the Aarhus Convention, environmental NGOs must have legal standing and the client status in environmental matters. Okay, so thank you for the invitation again, and I hope that I could give some additional and useful information. And finally, thank you very much for your sustained attention.